At 10:16 a.m. Eastern Standard Time, inside the marble chamber of the Supreme Court, 9 justices delivered a ruling that fractured a defense built on privilege, power, and presidential precedent. The room didn't erupt. It exhaled. Because sometimes the loudest verdicts are the ones delivered in silence. There's an old principle I learned decades ago in the boardrooms of America, immunity is just accountability on layaway. And on this morning, the bill came due. Stay to the end, because what unfolded didn't just strip a man of legal protection. It exposed the architecture of how power insulates itself from consequence. I've spent more than 60 years watching systems, markets, institutions, governments. And here's what I've learned, they all run on the same fuel. Trust. When trust fractures, everything built on top of it begins to tilt. This case wasn't just about one man or one presidency. It was about whether the office itself could become a shield, a legal force field that bends accountability until it breaks. So let me ask you this, if a president can delay justice long enough, does justice still exist? And if the answer is no, what does that say about the system we've built? Let's trace how we got here. Every story has players. And every player has an incentive. Donald J. Trump, former President of the United States. His incentive, delay. Delay the trial. Delay the evidence. Delay the clock until elections, appeals, or executive power could reset the board. In finance, we call this arbitrage of time. You stretch the timeline until circumstances change in your favor. It's not illegal. But it's not innocent either. Then you have the Department of Justice. Their incentive, precedent, they needed to prove that no office, not even the presidency, grants blanket immunity from criminal prosecution. Because if it does, the Oval Office stops being a public trust. It becomes a legal bunker. And finally, the Supreme Court. 9 justices. Lifetime appointments. No elections to worry about. Their incentive, institutional credibility, they knew that whatever they ruled would either reinforce the rule of law, or expose its limits. Listen closely. Delay is currency. And in this case, they were all negotiating the price. But there's another player most people overlook. The public. Not as a mob. Not as voters. But as the ultimate underwriter of institutional trust. Every time a system makes a promise it doesn't keep, the public withdraws a little more confidence. And confidence, once lost, takes decades to rebuild. The public's incentive here was simple, they wanted to know if the rules still applied. Not just to criminals on the street. But to power in the penthouse. Because if the rules don't apply at the top, they stop mattering at the bottom. That's not philosophy. That's structural reality. Let me explain something about trust. It's not emotional. It's structural. Trust is what allows contracts to exist without enforcement at every step. It's what lets you deposit money in a bank without armed guards standing next to the vault. It's what holds democracies together when nobody's watching. But trust has a balance sheet. Every action either deposits credibility, or withdraws it. And when withdrawals exceed deposits for too long, the account collapses. That's what happened here. For years, the American public watched as one question hovered over the legal system like smoke. Can a president be prosecuted while in office? Can a president be prosecuted after leaving office? And if so, under what conditions? These weren't academic questions. They were structural cracks in the foundation. And cracks don't heal themselves. They widen. I remember a conversation I had in 1987 with a federal judge in Omaha. He said something I've never forgotten, Warren, the law doesn't protect people. Process does. And when you let powerful people customize their process, you've already lost. That's the economy of trust. When rules bend for convenience, they stop being rules. They become tools. And tools cut both ways. Markets collapse when confidence does. Governments aren't any different. So when the Supreme Court agreed to hear this case, they weren't just deciding Trump's fate. They were deciding whether the system itself still had credibility. And that's a bet you can't afford to lose. The history of immunity claims goes back further than most people realize. Richard Nixon faced similar questions in the 1970s. His attorneys argued that executive privilege extended beyond his term. That a president's decisions, made in office, remained protected indefinitely. The courts disagreed, but only partially. They created a gray zone where civil liability could exist, but criminal prosecution remained theoretical. Untested. And that gray zone became a hiding place. For decades, legal scholars debated the question in classrooms and journals. But debate without application is just theory. And theory doesn't build trust. Application does. So when Trump's legal team invoked immunity, they weren't inventing a new defense. They were testing whether the gray zone still existed. Whether the system had evolved, or frozen. I've watched this pattern play out in corporate boardrooms too. A company faces allegations of fraud. The CEO claims legal protection under business judgment rules. Shareholders demand accountability. And the board has to decide, does leadership serve the institution, or does the institution serve leadership? The answer determines whether the company survives or implodes. In 2008, I watched Lehman Brothers collapse. Not because they ran out of money, but because they ran out of trust. Counterparties stopped believing their balance sheet. Investors stopped believing their risk models. And the entire edifice, built on leverage and confidence, evaporated in 72 hours. That's what happens when trust hits zero. The transaction costs become infinite. Nobody will deal with you at any price. Governments work the same way. When citizens stop believing that laws apply equally, they stop obeying them voluntarily. And voluntary compliance is what makes governance possible. Without it, you don't have a republic. You have enforcement theater. Now let's talk about what actually happened inside that courtroom. The case centered on whether Donald Trump could claim absolute presidential immunity from federal criminal prosecution for actions taken while in office. His legal team argued that without immunity, every future president would face endless lawsuits and political prosecutions. That the office itself would be paralyzed by legal threats. On the surface, that sounds reasonable. But here's what they didn't say. Immunity doesn't just protect presidents from frivolous claims. It protects them from legitimate ones too. And that's the gap where accountability disappears. The DOJ presented a 312-page filing. Inside it was a single sentence that changed the temperature of the room, no person in this country, no matter how powerful, is above the rule of law. Simple. Direct. Devastating. So what does that mean? It means the prosecution wasn't just arguing law. They were arguing philosophy. They were asking the court to decide, is the presidency a public office, or a private kingdom? And if it's a kingdom, what happens when the king misbehaves? The defense countered with precedent. They cited Nixon. They cited Clinton. They cited executive privilege cases dating back to the 1800s. But here's the problem with precedent, it only works when the situation is identical. And this situation wasn't. Because Trump wasn't being sued in civil court. He was facing criminal indictment. That's a different category entirely. Civil cases ask, did you cause harm? Criminal cases ask, did you break the law? And the law doesn't care about your title. It cares about your actions. The room froze when Chief Justice Roberts asked the defense attorney a single question, counsel, are you saying a sitting president could not be prosecuted even for murder? The attorney hesitated. That hesitation said everything. Because in that moment, the entire immunity argument collapsed into absurdity. If you can't answer a hypothetical about murder without hedging, you're not defending a legal principle. You're defending a loophole. And loopholes don't build systems. They hollow them out. The defense tried to recover. They argued that such extreme scenarios would be handled through impeachment, not prosecution. That Congress provides the check on presidential misconduct. But impeachment is political, not legal. It requires a 2/3 Senate vote to convict. And in a polarized system, that threshold makes accountability nearly impossible. So what they were really arguing was this: a president can commit crimes, but only Congress can hold them accountable, and only if it's politically convenient. That's not a legal system. That's a popularity contest with jail time on the line. Let me show you something most people missed. Buried in the court filings was a memo dated November 14, 2023. It was written by a deputy White House counsel during Trump's final weeks in office. The subject line read, legal exposure post-transition. Inside, there were 8 pages of scenarios. Each one outlined a potential prosecution pathway and a recommended defense strategy. But here's the line that mattered, presidential immunity remains untested in criminal context. Recommend full delay strategy until SCOTUS clarification. That's not legal advice. That's a roadmap for delay. They knew. They knew the immunity argument was weak in a criminal case. So they built a timeline strategy instead. Delay until the court had to intervene. Delay until elections shifted the landscape. Delay until the public forgot or moved on. Because silence is just guilt in slow motion. And time is the best lawyer money can buy. Now, some might say this is standard legal strategy. That every defendant has the right to exhaust every appeal. And that's true. But there's a difference between exercising your rights and weaponizing process. When you file motions not to win, but to delay. When you appeal not because you believe you'll prevail, but because you need more time. That's not defense. That's obstruction dressed in procedure. And the memo proved it. The strategy wasn't built on confidence in the law. It was built on confidence in the clock. I saw this same tactic in the early 2000s with Enron. As the accounting fraud unraveled, the company didn't rush to settle. They delayed. They filed motions. They requested extensions. They appealed every ruling. Not because they had a defense. But because delay gave executives time to liquidate stock, move assets, and build personal legal teams. By the time the case concluded, the company was bankrupt. But the individuals had already protected themselves. That's the incentive structure of delay. It doesn't serve justice. It serves self-preservation. Here's what the media didn't cover. This case wasn't really about Trump. It was about the mechanism of accountability. Think of it like a valve in a pipeline. If the valve works, pressure gets released before it explodes. If the valve rusts shut, the whole system fractures. Presidential immunity was that valve. And for decades, it stayed closed. Not because it was legal. but because it was never tested. Nobody wanted to be the one to prosecute a sitting president. Too risky. Too divisive. Too unprecedented. So the valve stayed shut. Until it couldn't anymore. The problem isn't the delay itself. It's who controls the clock. And in this case, the clock was controlled by the very people it was supposed to hold accountable. That's not justice. That's leverage. I've seen this pattern in corporate governance too. A CEO facing fraud allegations. They control the internal investigation. They control access to documents. They control the timeline of disclosure. And by the time the truth emerges, the statute of limitations has expired. Or the company has settled quietly. Or the executive has moved on to another position. The mechanism of accountability existed. But it was controlled by the person who needed to be held accountable. That's not a flaw in the system. That's the system working exactly as designed, for the person at the top. In engineering, there's a concept called a single point of failure. It's a part of a system that, if it fails, causes the entire system to collapse. Presidential immunity is a single point of failure in the legal system. If that one mechanism doesn't work, the entire structure of accountability collapses. And that's exactly what Trump's legal team was testing. They wanted to know if they could break that single point. And for a while, it looked like they might succeed. Let's talk about what comes next. Because legal rulings don't end with gavels. They ripple. Scenario 1, immunity is denied if the Supreme Court rules that Trump has no immunity from criminal prosecution. Every legal case pending against him accelerates. The federal trials move forward. The state cases gain momentum. And the 2024 election becomes a courtroom marathon. But here's the deeper effect: every future president now knows they can be prosecuted after leaving office. That changes behavior. It restores accountability, but it also weaponizes the DOJ. Because once you open that door, both parties will walk through it. Republicans will prosecute Democratic presidents. Democrats will prosecute Republican presidents. And the office becomes less about governance and more about legal survival. That's not necessarily bad. It might be necessary. But it's a fundamental shift in how power operates. Future presidents will govern with one eye on the law and one eye on their legacy. They'll hire more lawyers. They'll document more decisions. They'll avoid gray areas. That could lead to better governance. Or it could lead to paralysis. Time will tell. Scenario 2, partial immunity is granted. The court could split the decision. Grant immunity for official acts, deny it for personal conduct. That sounds clean. But it's a legal minefield. Who decides what's official? Is pressuring election officials official? Is asking the DOJ to investigate rivals official? Is withholding documents official? Is obstructing an investigation official? Every action exists in a gray zone between policy and conduct. And gray zones don't protect the law. They just delay the next case. This scenario kicks the problem down the road. It creates more questions than it answers. And it guarantees that we'll be back in this courtroom within a decade. Partial immunity is like partial trust. It doesn't work. You either trust someone or you don't. You either hold them accountable or you don't. There's no middle ground that satisfies both principle and pragmatism. Scenario 3, full immunity is upheld. If the court grants Trump full immunity, the rule of law doesn't just bend. It inverts. The presidency becomes untouchable. And future presidents, from both parties, inherit a legal force field that makes them immune to criminal consequence. That's not democracy. That's monarchy in a suit. Imagine a future president who knows they can't be prosecuted. What would they do? Would they follow norms? Would they respect constraints? Or would they test the boundaries until the boundaries disappeared? Human nature doesn't change just because you put on a different title. Power without accountability always trends toward abuse. Not immediately. Not obviously. But inevitably. If the court acts with clarity, trust survives. If it hedges, precedent expires in confusion. And confusion is where accountability goes to die. Now, some will argue this is all political theater. They'll say Trump is being targeted because he's a threat to the establishment. That prosecuting a former president sets a dangerous precedent. That this is about power, not justice. Let me respond to that. I've watched political theater for 7 decades. I know what it looks like. And this isn't it. Political theater is loud. It's performative. It's designed to distract. What happened in that courtroom was the opposite. It was quiet. It was procedural. It was built on documents, not tweets. And here's the key: if Trump committed no crimes, the evidence will show that. If he did, the evidence will show that too. But you can't know unless the process runs. And immunity stops the process before it starts. They'll call it national security. They'll call it protecting the office. But secrecy stops being protection when it starts protecting the powerful. Documents don't blink. They don't forget. And they don't negotiate. The objection sounds reasonable until you examine the incentive. Who benefits from immunity? The person being investigated. Who suffers from immunity? The public that depends on accountability. That's not balance. That's bias built into the structure. And here's the thing about bias: it compounds over time. The first time you let someone bypass accountability, it's an exception. The second time, it's a pattern. The third time, it's a precedent. And after that, it's just how things work. That's how systems degrade. Not through one catastrophic failure. But through 1,000 small compromises that seemed reasonable at the time. Let me tell you about process. It's boring. It's slow. It's frustrating. But it's the only thing that keeps power from becoming permanent. I built Berkshire Hathaway on process. Not instinct. Not charisma. Not luck. Process. Every investment decision we make follows a checklist. Every acquisition follows a framework. Every quarterly report follows the same structure. Why? Because process removes ego from the equation. It makes decisions auditable. It makes mistakes visible. And it makes power accountable. The legal system runs the same way. You file charges. You present evidence. You allow a defense. You let a jury or judge decide. And you accept the outcome. That's process. And when process is bypassed, when someone says, "I'm too important to follow the same rules," the system stops being a system. It becomes a hierarchy of privilege. And hierarchies collapse under their own weight. I've seen it in companies. CEOs who thought they were untouchable. Boards that let executives write their own rules. Shareholders who looked the other way because the stock price was up. And every single time, the collapse came. Not because the rules were broken. But because there were no rules left to break. Presidential immunity works the same way. If the president can't be prosecuted, then the president isn't bound by law. And if the president isn't bound by law, then law is just a suggestion. Documents don't blink. They don't care about popularity. They don't care about power. They just sit there, waiting to be read. And when they finally are, the truth doesn't arrive in a thunderclap. It arrives in silence. Like a door closing that you didn't know was open. I learned this principle early in my career. In 1964, I took control of Berkshire Hathaway. It was a failing textile company. The previous management had made promises they couldn't keep. They'd delayed difficult decisions. They'd hoped the market would turn around. It didn't. And by the time I arrived, the damage was structural. I could have blamed the market. I could have blamed competition. But the real problem was process. Or the lack of it. There was no accountability for capital allocation. No transparency in decision-making. No consequences for failure. So I built a process. Simple. Boring. Repeatable. And 50 years later, that process is still running. Not because it's perfect. But because it's consistent. The Supreme Court ruling on immunity was the same choice. Build a process that applies to everyone, or build a hierarchy that protects the few. They chose process. And that choice will echo for generations. But here's what concerns me. Process only works if people believe in it. If the public sees the court as partisan. If they see prosecution as political revenge. If they see justice as selective. Then process becomes theater. And theater doesn't hold systems together. It just delays the collapse. That's the real test ahead. Not whether the court ruled correctly. But whether the public accepts the ruling when it's inconvenient. When their candidate is the one facing charges. When their party is the one being held accountable. Because principles only matter if you apply them universally. And universal application is the hardest thing in the world to maintain. So here's the lesson. And it applies to governments, companies, and people. When rules bend for convenience, they stop being rules, they become tools, and tools cut both ways. Trust isn't built on perfection. It's built on consistency. On the willingness to apply the same standard to everyone, even when it's uncomfortable. Especially when it's uncomfortable. The Supreme Court didn't rule against Donald Trump. They ruled for process. They ruled for the idea that no office, no matter how powerful, grants immunity from accountability. And that's not a political statement. It's a structural one. Because once you let one person bypass the system, you've taught everyone else that the system is optional. And optional systems don't survive. They dissolve. Slowly at first. Then all at once. I've lived long enough to watch institutions rise and fall. The ones that survive aren't the ones with the most power. They're the ones with the most discipline. The ones that enforce their own rules, even when it hurts. That's what separates a republic from a kingdom. And that's what this case was really about. Not Trump. Not politics. Not even immunity. It was about whether the system still believed in itself. And on that morning, in that marble chamber, the answer was yes. But let's be honest. The answer was barely yes. The vote wasn't unanimous. The reasoning wasn't ironclad. And the political pressure was immense. This wasn't a triumph. It was survival. And survival isn't the same as strength. The system held, but it held by a thread. And threads can snap. So the real question isn't whether the court ruled correctly. It's whether the public will defend that ruling when it becomes inconvenient. When their candidate is the one being prosecuted. When their party is the one facing accountability. Because principles don't mean anything if you only apply them to your opponents. That's the test ahead. Not for Trump. For all of us. I think about this often when I review our annual shareholder letters at Berkshire. Every year, I write about our mistakes. Not because I enjoy admitting failure. But because transparency is the price of trust. If I only reported our wins, shareholders would stop believing the wins were real. Accountability isn't about punishment. It's about credibility. And credibility is what makes long-term relationships possible. Whether you're running a company or a country. The same principle applies. If this kind of clarity matters to you, if you believe that understanding the architecture of power is more valuable than reacting to headlines, then subscribe. Because every week, we go deeper. Not louder. Deeper. We examine the systems that shape our world. The incentives that drive decisions. And the documents that reveal what really happened when the cameras were off. Next episode, we'll explore the 3 signals that decide whether institutions hold, or fracture. It's not what you think. And it's already happening. I'll see you there. Within 6 hours of the Supreme Court ruling, headlines flooded every screen. Not just in America. Globally. Trump immunity rejected, trials to proceed, Supreme Court restores accountability, constitutional crisis averted, or just delayed. Hashtags trended for 72 hours straight. Hashtag no one above the law, hashtag immunity stripped, hashtag SCOTUS ruling. But here's what didn't trend, the memo. The timeline. The architecture of delay that almost worked. Because the public sees the verdict. But they rarely see the valve. And the valve is where the system either holds, or fails. On that day, it held. Barely. But it held. And in a world where trust is the rarest asset we have, that might be enough. For now. The truth was never hidden. Only delayed. By the end of that week, legal analysts had published over 200 articles. Constitutional scholars appeared on every cable network. Law professors held emergency seminars. Everyone was trying to understand what this ruling meant. But the answer was simpler than most wanted to admit. It meant the system still worked. Not perfectly. Not smoothly. Not without strain. But it worked. And in a world where institutional trust is collapsing everywhere you look, that's not nothing. That's everything. The question now is whether we can maintain it. Whether the next president will respect the precedent. Whether the next Congress will defend the process. Whether the next generation will value accountability more than partisanship. Those are the real tests. And they're just beginning. You don't protect democracy by delaying it. You protect it by defending the process, even when the outcome is uncertain. Even when it's uncomfortable. Even when it costs you. Because in the end, trust is the real currency. And once you spend it, you can't get it back. I've made a career out of investing in trust. Not companies. Not stocks. Trust. I invest in businesses run by people who do what they say. Who follow the same rules in private that they claim to follow in public. Who understand that reputation isn't built overnight, but it can be lost in an instant. That's the economy we all live in. Whether you're running a company, a country, or your own life. Trust is the real currency. And the Supreme Court just reminded us what happens when you try to counterfeit it. The system caught it. This time. But counterfeits are getting better. The techniques are getting more sophisticated. And the people trying to game the system are getting smarter. So the question isn't whether we won this round. It's whether we're prepared for the next one. Whether we've learned the lesson. Whether we've reinforced the valve before the next pressure test. Because the test will come. It always does. And when it does, the system won't be saved by the Supreme Court. It'll be saved by the public that demands accountability. Or it won't be saved at all. That's the choice we all face. Not as Democrats or Republicans. But as citizens of a republic that only works if we make it work.